Hello and welcome in the Privacy Rules Privacy Espresso series. My name is Matthew Newman. I'm a reporter at MLex, and we're here to bring you the latest news on privacy, data protection, and cybersecurity from around the world. I'm very pleased to introduce a partner at Timelex. His name is Ruben Roex, and he has been representing a complainant in a very, very long-running case involving IAB Europe, and this is a case that's reached a very crucial point. We had a ruling by the Brussels Market Court very recently. Ruben has been representing these complainants with his colleague Frédéric Dubusseret before the Belgian Data Protection Authority. So just briefly to talk, to give a very, very general view of what the case is. The Data Protection Authority found that IAB's Transparency and Consent Framework, otherwise known as the TCF, you might hear that acronym during this next 10 minutes, that was a violation on multiple levels by of the GDPR. And the TCF, to the uninitiated, is a mechanism that helps websites manage user preferences. And this is for online ads. So when you see those pop-up banners, that's what the TCF is all about. It's for real-time bidding and the whole ad tech industry uses it very widely to auction space on websites. What was the problem? Well, there was a data protection breach, and we will hear more about that from Ruben. Just to a couple more words, we had the IAB lost at the Data Protection Authority. It was found that there was a violation. They appealed at the Brussels Market Court, which referred questions to the Court of Justice. They essentially upheld the Data Protection Authority's decision, and then that was sent back to the Market Court, which again upheld the Data Protection Authority's decision and a 250,000 euro fine, I might add. So that is a couple words of introduction. We'll get into much more details. Ruben, to kick us off, besides what my brief overview, what is some of the background of the IAB Europe case, and what were the complainants trying to achieve with their complaint?
Yeah, thanks, Matthew. So in essence, the case started almost around the same time when the GDPR came about, because back in 2017, some of the complainants had issued a petition to the Commission to reveal certain files to be revealed under the rules regarding the disclosure of public documents. And it turned out, as part of that request, that IAB Europe at the time was aware of the fact that the system called OpenRTB, so the real-time auctioning of online space, the mechanism behind it, that it was in direct violation of the upcoming GDPR. And so what the Adtech industry tried to do was, how do we reconcile a mechanism where you auction off people's personal data in real time, so in microseconds? How do you reconcile such a system with the fact that you have to obtain, for most of these processing activities, consent, and you must be able to propagate that consent signal throughout an ecosystem with thousands upon thousands participants in real time? So how do you reconcile the need for consent with a system that operates in real time? That was the need. And that's where IAB Europe came in with the TCF. So it was a response of the Adtech industry, here represented by IAB Europe, to the problem that OpenRTB faces with data protection law in Europe. And they thought that they had found the magic bullet, the silver bullet, with the TCF. And so the complainants, they uncovered that this TCF mechanism is nothing but a faire semblant, a mechanism that makes it seem as if people give informed consent as they should under the GDPR, but in fact, it's something a mechanism that serves very little purpose, but to provide the Adtech industry with a rather weak argument by saying, look, we can continue with what we're doing under the GDPR. So that was sort of the main background to this case.
Excellent. And so the Belgian DPA ruled that number one, that there was personal data being
Yes.
processed. That was one of the key arguments. And then they also decided that there was joint controllership. So those two things were they the key findings by the authority?
Yeah, I think those are two important elements that will continue in the future on the basis of this decision. So one point, a key element of the TCF is that the consent signal that a user gives on a website has to be propagated through the ecosystem. It happens through a string of several segments. That string captures user consent and then gets propagated throughout the ecosystem. The string itself, the way it's structured, that's completely decided upon by IAB Europe. So the technical implementation to a large extent is decided upon by IAB Europe. The Court of Justice, and now confirmed by the Markets Court, is that this string is personal data because it captures user preferences and is always tied to an IP address, because you can't propagate a string without also sending the IP address of the user. That's the way the internet works. And secondly, what's also very important about this decision is that the Market Court found that in this case, IAB Europe, as sector federation, has so much deciding influence on how this whole mechanism works that they cannot claim we're only a standard setting body, we're more. We have so much influence that we decide how the TCF works, and therefore IAB Europe must be seen as a controller jointly with the organizations that implement the TCF typically, which are our consent management platforms, publishers, etc.
And that's quite significant because I think the people really paid attention to this case. It was by far the biggest case out of Belgium because I think a ruling against the IAB Europe system could have had a massive effect on the industry. And that was because the Belgian authority decided it wasn't just joint controllership with the TCF participants, but it was the further on processing. And
Yeah.
can you explain that a little bit and what happened with that part of the decision?
Yeah, sure. So the Data Protection Authority found that IAB Europe, due to the fact that the TCF also sets forth the purposes for processing that participants to the TCF can choose when asking for a user to consent to particular processing activities within the frame of OpenRTB or the other Adtech solution. Given that IAB Europe proposes which purposes you can choose and chooses the wording, the DPA in Belgium went a step further than the complainants really and said, well, we should also hold the IAB Europe responsible as a controller for what happens in that further processing once the TC string has been generated, user preference has been captured. Once that string gets propagated through the ecosystem using the template provided by IAB Europe, we believe that IAB Europe should be responsible for that part as well. And that's where the Markets Court and actually the Court of Justice already hinted upon this as well, both felt that this was one step too far. IAB Europe, without a shred of a doubt, is responsible for what happens within the TCF, but cannot be said to be responsible for what happens afterwards.
Gotcha. And just to be clear, what does that mean, joint controllership, in terms of liability? Could they potentially have been sued or could be sued in the future?
Well, of course, anyone that participates in this ecosystem following the terms and conditions and the policy set forth by IAB Europe, therefore entering into this joint controller arrangement that the Market Court has now identified. Anyone that participates in that ecosystem but does not follow the rules and is held in infringement of those rules based on following the TCF by a Data Protection Authority or subsequent to a complaint, of course, that would allow the Data Protection Authority or the complainant to pull in IAB Europe into this case as well, into this complaint or investigation as well. That makes a lot of sense. Ultimately, IAB Europe still is the controlling entity over what a participant to the TCF should or should not do in terms of the way you capture user preferences.
Okay. So Ruben, just to get to the decision from the Market Court just recently, because there's been some reporting of it that hasn't been completely accurate, and some of the things that I've read have said that the TCF was declared illegal. I'm just wondering if you could set the record straight on that.
Yes, to an extent, of course, several of the core principles which underpin the TCF have indeed been declared illegal, to the extent that the position that IAB Europe maintains that the TCF in itself does not process personal data, that's found to be incorrect, and therefore using the TCF as prescribed by IAB Europe without complying with all the obligations in full under the GDPR would make the use of the TCF illegal. In addition to that, and I think that's very important to stress, the Markets Court found that one of the big problems with the TCF is that it is very hard to ensure that when you process personal data as a consequence of using the TCF, that it's very hard to ensure that the security requirements imposed by the GDPR under Article 32 and Article 5.1f are complied with. Because imagine you are propagating user preferences throughout a whole ecosystem, but you have no way, it's impossible to know what will happen with those personal data once they are received by these thousands upon thousands participants in the ecosystem. You can't verify that they comply with user preferences, that they store it securely, that they don't create fake TC strings, etc. And that's what the Markets Court said. You don't have a mechanism to check that a CMP and a publisher collude and generate fake TC strings. There's no mechanism to check this. And to be honest, it's technically impossible to do it at scale. Therefore, there is a fair chance that even TCF 2.2 or even later versions will be considered illegal just in the same way as TCF 2.0 was.
Okay, so just to put us back in what's happening now, because this case has been going on for so long,
Yes.
you just mentioned the TCF version 2.2. What is the next step in all this? Is the Belgian Data Protection Authority going to have to reopen yet another case and look at the latest version?
Well, I think the first step, of course, will be IAB Europe had to comply with an action plan. That action plan is still the subject of an additional appeal, both by the complainants as well as by IAB Europe itself. So that case still has to be reactivated and followed up. And of course, with TCF 2.2 not being the object of this decision, but the underpinning principles being the same as with TCF 2.0, that means that the newer and future versions of the TCF, to the extent that they remain compatible with the present system, will of course be subject, I imagine, to additional complaints by other complainants on the basis of the same principles, which have now been declared invalid or illegal by the Markets Court, for sure.
And just to keep our listeners up to the very latest news on all this, can you just tell us what happened just this week with a lawsuit, a class action lawsuit against Microsoft and the same RTB system, and this was in Ireland?
Yes, so one of the complainants, Johnny Ryan with the ICCL in Ireland, has gotten the permission from the Irish court to proceed for the first time ever with a class action against Microsoft as being one of the leading companies that uses the OpenRTB mechanism as designed and published by IAB in New York, to go after them and to challenge the OpenRTB system in and of itself, not the consent framework that should legalize OpenRTB, but the mechanism in and of itself. And Microsoft is one of the tech vendors that heavily relies on this technology.
Excellent. Ruben, thank you very, very much. You've really taken a very complex case and boiled it down for us. I want to thank our listeners for tuning in, and tune in next week for our next series in the Privacy Rules PrivacyEspresso. Thank you very much. This has been Matthew Newman from MLex and Ruben Roex from Timelex. Thank you very much for listening.
Thanks, everyone. Thanks, Matthew.